coming. What's that? What's that?
Feels like somebody was in here.
So do we want to go ahead and do the motion now? So both sides ready for that?
And we're in headphones, so you need to use your mics. Either mic, you can use one in front of you. Either one, I think.
All right, so we're here in FECR 153477, State of Iowa versus McKinley Louisma. The state is present by Lynn County Attorney Nick Maybanks, First Assistant Monica Slaughter. Defendant is present with Attorney Jill Eimerman. Matthew Moore is not present, but I understand is coming. Ms. Eimerman, you indicated before we went on the record that the motion that we were here to argue is a motion that you had filed and that you were arguing. Is that correct?
It is correct.
And are you prepared to go forward in Mr. Moore's absence today?
I am.
All right. And so the motion that we're going to hear is this not working? All right, great. All right, so the motion that we're here for is the defense's objection to amendment to minutes of testimony and motion to exclude that was filed November 1st. I've reviewed that. We've also received the defense's facts in support of objection to amendment filed on November 3rd, and I've received the state's resistance to defendant's motion to exclude filed this morning, November 4th. My understanding is that this motion concerns the state's proposed exhibits 10M-1 through 10M-4, which are text messages received through the Text Now service. Is that correct, Ms. Eimerman?
Yes, Your Honor.
And then the associated testimony that would be offered by Special Agent Ryan Kedley and Megan Hoffman. Is that correct?
Yes, Your Honor.
All right. Would you like to be heard on the motion?
Your Honor, I filed both the motion and I filed my additional support, and I would stand on that.
All right. Before I let the state respond, one thing I wanted to highlight and let each side be aware of and respond to is it appears to me that both sides are citing to the rules of criminal procedure that predate our current rules. And there are differences on this particular issue between those two rules. So the current rules were effective July 1st, 2023. Applied to criminal cases already pending on that date. This case was filed in 2024. And I think importantly, under the new rules, the indictment and information was separated from the minutes. I don't know that it substantively matters, but that language about bringing a wholly new charge is no longer part of the rule as it pertains to minutes under the new rules. And so I just would like the defense and then the state to have an opportunity to comment on that if you believe that I'm incorrect or that you think that it's not a meaningful difference. But as I look at the rules, the rule of relevance is Rule 2.19 sub 2. And the amendment rule is Rule 2.4 sub 7B.
Thank you, Judge. Would the court allow me to remain seated?
You please do.
Okay, thank you. I appreciate the distinction that the court is making and noticed that when I was looking at some of the cases. I do believe that there is very much a distinction. However, in this case, I think it's moot in that I think both apply. When you look at the trial information, the actual charging document, it refers to kidnapping, I think, in basically the definition and then kind of the elements. It doesn't specifically delineate which of the theories it is alleging. However, the language of the trial information does set forth which of the theories of kidnapping. So I believe that this amendment is, in fact, an amendment to the trial information and the charging document in that it adds an additional theory that was not otherwise pled. I also believe that there is an issue with the minutes of testimony because the minutes of testimony do add additional and new facts to the case. So again, yes, I agree with the court that there is a distinction. However, in this case, I believe what the state is seeking essentially violates both.
At this point, the state is not asked to amend the trial information to seek a different theory, but factually these minutes do that.
Correct.
And my main point, though, was just to indicate that I think the operative rule with regard to minutes is Rule 2.19 sub 2, and so I wanted to give an opportunity to indicate whether you agreed with that or disagreed.
I do agree with that, and I would ask that, I guess to the extent that my written motions don't delineate that in my argument, I am addressing both of those. Thank you.
Great, thank you. Would the state like to respond?
Thank you, Your Honor. Yes, as the court has made counsel where Rule 2.19, subsection 2 of the Iowa Rules of Criminal Procedure, the 2024 new edition here does not contain language involving amendment minutes that would present a wholly new different offense. However, even if that was the standard under the case law cited by the state and its resistance, we believe that this is not a wholly new different offense. This is simply defendant was the one who sent this, or that an accomplice of the defendant did so. We believe that given the entirety of the evidence here, that this is not fairly prejudicial, and we know that to the extent that it is important that the investigation test down on whether it's still going.
Can you talk to me a little bit about the circumstances by which this would have only been provided to your investigator, as I understand it, on October 30th? Is that right?
That's not right, Judge. I didn't make that clear in my resistance. So this was provided to the investigator on February 18th. During a meeting with Melody Hoffmanin, Megan Hoffman, she brought that up because it wasn't documented before. I didn't know that. And so I confirmed that it was sent to Special Agent Kelly, who did describe to me that he recalled that, but believed, and this would be evident in the exchange between Special Agent Kelly and Megan Hoffman, that it was some sort of prankster or somebody trying to restore her under circumstances, and so he didn't take any documentation of it at the time. Because I beg to differ on the importance of that, I had him do it to be in supplemental report and provide the defense with those messages. It's not an ideal way that it came about. It's the way it came about.
And so I guess I misread it then or misunderstood it. So what you're indicating is that Megan Hoffman provided the messages to the investigator on February 18th, and then when did the state become aware of it from the investigator?
I became aware of it from Megan Hoffman on Tuesday, October 29th.
Okay, and so then you became aware, and as soon as you became aware, you immediately notified the defense.
I confirmed the existence of taken messages and notified the defense just prior to filing this testimony within about 24 hours of Megan Hoffman's time.
And so, you know, under rule, and I guess I asked this question to the defense, do you also agree that Rule 2.19 sub 2 is the operative rule for me to consider here, which says that for minutes filed less than 10 days before trial, which includes amended minutes, that if I were to allow that the court can order the state to permit the discovery of the witness, grant a continuance, or enter such other orders deemed just under the circumstances, and if no less severe remedy is adequate to protect the defendant from undue prejudice, to order exclusion of the testimony. Yeah, the whole thing was a question.
We would contend that under 2.19 subsection 2 that this is not we're not introducing a new witness. Megan Hoffman's already been a witness in this case. It's just the particular item or incident at hand that is. So we would then say that the court would refer to the analysis in subsection B of that rule in subsection discovery, grant continuance, or another order being just the most severe remedy here of the exclusion.
So, I mean, obviously, we're beyond a continuance. Permitting discovery of the witness at this point, I mean, what the defense has said in their motion is that, you know, the bulk of the state's case is going to be put on this week. They've already deposed, the investigator already deposed Melody Hoffman. I mean, what's the remedy? I mean, the more significant the evidence, and you've just made an argument that it's significant, the more important that they have an opportunity to meet it. And one concern I have is I'm not aware of any other evidence that the state has to suggest kidnapping by ransom. And so while this is not a wholly new offense, it's a wholly new way of meeting this offense that the state has no other evidence of.
So we would get that if you have other evidence to support this. As has been laid out in minutes of testimony and as the evidence in this case will support, the defendant and Mr. Van Patten, while Melody Hoffmanin was bound and confined within the vehicle they were driving, left Morgan Creek Park and headed directly back towards the residence of Melody Hoffmanin, where Megan Hoffmanin was. And there's very little explanation in the evidence in this case for why they would do that, other than they were intending to make some kind of contact with Megan Hoffmanin. Not that it's part of the case, but there's also information that came from a co-defendant on that regard, but that's not something that the court would be able to consider. In any event, that does rise, or at least arise, the distinct prospect that that could have been one of the intents of the co-defendants in this case.
Doesn't sound like anything that's going to rise to the level of getting a ransom instruction that I'm hearing.
Yeah, there's no other evidence of a ransom instruction other than their activities and movements toward the Megan Hoffmanin residence and then this subsequent text message of the same.
So, I mean, my issue is the more you tell me about the importance of the evidence, the higher the prejudice it is if they not have some ability to conduct discovery on it. What the defense says in their resistance is, and I think it's a fair point, is that we are now in the bulk of the state's case that we presented over the next 5 days. At minimum, it would seem fair that they would be able to depose the two witnesses.
Absolutely. If that's the remedy would be the best fix for the situation, the best way to address the situation, we would accommodate that.
Yet they say that, you know, time is limited. We're in the middle of the week. That if they do that, they're not doing something else that's essential. And of course, the rule says, or enter such other order deems just under the circumstances. I'm not sure what other remedy there would be other than exclusion.
Your Honor, yes. So we would defer back to our position that even if these messages aren't ultimately used to be able to add a theory to the case, that being the intent to hold Melody Hoffmanin for ransom, that it does indicate and is incriminating toward the defendant due to the, again, the timing of the message, the nature of the content, knowledge that the person who sent that would have had, and in particular the knowledge of Megan Hoffman's text or her phone number at the time this happened, as well as I believe that there will be similar syntax used in this message as Mr. Louisma has used in prior correspondence. So we contend it's a probative item of evidence, even if it's not used in the ransom theory.
Well, and again, the problem is that's a double-edged sword, because the more probative, the more prejudicial if the defense not have an opportunity to meet it. I mean, it's sort of inconceivable to me that a message sent from someone with knowledge prior to information being publicly available would not be included in an investigative report and turned over to the defense. It's inconceivable to me. And that this is not blaming the state. It sounds like you were not aware of it, and as soon as you were aware of it, it was immediately turned over. But in terms of the state actor of the investigator, it's inconceivable to me. Would the defense like to respond to any of this? And is any of what's been said different factually than what you understood when you were filing your resistance or your motion?
Your Honor has essentially articulated all of my concerns, and the more the state spoke, the more concerned I became about the substance of this evidence and its potential impact. It is far less superficial than I even initially thought it was. So I had not understood any of the evidence that I've learned over the course of this case to give rise to the theory of being held for ransom. I believe what the state has indicated today is tenuous at best, and as the court pointed out, likely insufficient to get a jury instruction on that. So at this point, I believe the only remedy that the court can really impose is to exclude the evidence.
And would you, though, respond to, again, the less severe remedy, because the rule does, of course, caution the court that exclusion is to be seen as the last resort. In terms of those other options of permitting discovery, you indicated in your motion that the defense, in effect, didn't have time to do that, didn't want to do that, that it would take away from necessary trial preparation. That was made as sort of a conclusory statement. I certainly don't want you to get into anything that would invade, your private preparations, but can you give the court any additional information about your ability to conduct that discovery if it were permitted in short order?
I can, and I expect that this court knows well what goes into setting up depositions. If the court were to permit us to take depositions, which, to be clear, is not the remedy that we are seeking, because at this point, it's no small thing to do that, Your Honor. We've got 2 witnesses who would need to be deposed. We would need to find a time that would work. We would need to find a location. I would probably be tasked with finding a court reporter that was available. I would need to find a court reporter that is available to do this on a rush job, that would be able to turn around transcripts essentially immediately. At that point, are we going to be required to do that outside of trial time, or would we recess the jury and allow us to do it then? Again, this is time that, when added up, is substantial, and it's time that we are taken away from preparing to defend our client in this case. So for that reason, Judge, we're not asking for the remedy of discovery. We're asking for the remedy that it be excluded.
Thank you.
Thank you.
Would State like any further word on this? All right, well, I am actually prepared to rule on this. So, upon under Rule of Criminal Procedure 2.19 sub 2, the state is not permitted to introduce any witness whose minutes of testimony were not filed at least 10 days before trial, and that includes amended minutes under Rule 2.47b. If filed within 10 days, the court may order the state to permit the discovery of such witness, grant a continuance, or enter such other order it deems just under the circumstances. And if no less severe remedy is adequate to protect the defendant from undue prejudice, the court may order the exclusion of the testimony of any such witness. Obviously, the purpose of the rule requiring minutes is to provide the defendant with a full and fair statement of the anticipated testimony. An amendment within 10 days before trial may certainly be permitted, but only if it can be done in such a way as to protect the defendant from undue prejudice. Here, the additional minutes were filed on October 30th at 3:06 p.m., stating that previously listed witnesses Ryan Kedley and Megan Hoffman would testify that Megan Hoffman provided Kedley with screenshots of a text conversation she had with an unknown sender from a text now number approximately 10 hours after Melody Hoffman's body had been located in Iowa County. I have reviewed the text now messages which were loaded as state's proposed exhibits 10M-1 through 10M-4. Significantly, the messages from the anonymous sender include a demand for money in exchange for the safe return of Melody Hoffmanin. Megan Hoffman was prompt in providing the messages to the investigator upon receipt. It's unknown why the investigator did not include this information in its report. Once the state became aware of the existence of the text messages, it was prompt in providing the information to the defense, but it's undisputed that this information was not provided to defense counsel until the state emailed defense counsel on October 30th at 2:49 p.m., immediately before filing the additional minutes. The defense previously took depositions of both Megan Hoffman and Special Agent Kedley, and the information was not known or revealed, so the defense has had no prior opportunity to explore or follow up on the evidence. The court does find that this evidence is not merely superfluous or supplemental for the primary reason that it provides evidence for an additional element not previously alleged in the facts by which defendant could be convicted of kidnapping. In Iowa Code Section 710.1, the definition of kidnapping requires that the act be accompanied by one or more items, one of which is the intent to hold a person for ransom, and the text now messages is the only direct evidence that the court is aware of in this case, which would support a kidnapping conviction based on ransom. Additionally, while the text now messages are anonymous, the evidence is nonetheless somewhat probative of identity in this case, particularly due to the court's limine ruling that a separate anonymous text now message sent around the time of defendant's breakup with the alleged victim could be received based on the content and timing of that message and based on Megan Hoffman's expected testimony that Melody Hoffman had no one else in her life that would send such a message at that time. Assuming that the jury believes that the defendant sent the earlier message using the text now service, it's more likely that the jury may believe that the later text now messages were also sent by the same sender. Given that the text now messages provide an additional basis for kidnapping and may have additional probative value regarding identity, the defendant's need for further investigation is not imagined or exaggerated. It is not the type of exploration that would wisely be done cold through cross-examination in front of the jury. Obviously, continuance of trial cannot be granted at this point. The court has considered whether it can permit discovery of the witness or provide other remedies, short of exclusion, to provide the defendant and protect the defendant from prejudice. Defense counsel has stated that it cannot devote time to investigate these details with the two witnesses without sacrificing time otherwise needed in trial preparation, which the court finds to be a reasonable position, given that almost the entirety of the state's case will be offered this week. An investigation of these details would at minimum require additional depositions of the two witnesses and potential other follow-up. This is information that was in possession of the state's witness back in February, hours after Melody Hoffman's death. It's simply not fair or reasonable to expect defense counsel to now use its trial preparation time to chase a new discovery issue and be faced with defending a new theory of kidnapping during the week that the state is putting on almost the entirety of its case. While the court finds that exclusion of evidence should be a last resort, it is unfortunately the only remedy available to the court under the timing and circumstances which will avoid undue prejudice to the defendant. Therefore, defendant's objection to amendment to the minutes of testimony for witnesses Megan Hoffman and Ryan Headley as to the text now messages filed October 30, 2024 is sustained, and the motion to exclude that testimony and those proposed exhibits is granted. So let's go ahead and take just a few minute breaks so you can get set up for your openings, and while we're doing that, if you want to test your tape, you can do that as well. Go off the record.
All you have to do is hit that thing until the,
It was showing that it was on up there.
can I see it?
No, give it just a minute, please. It's got a green light, so I have to give it a minute here.
There's 2 different stages of green lights, though.
Right, yeah, it's not solid, so. Because it turns off red when we turn this off, so.
Hold, can I push this for it? This is what we do.
I know we've had, yeah.
Don't do that one off. I can do it from here. So. Come through, but your lapel does.
Oh, okay.
So he'd prefer. Something for the preview, because I can just leave it kind of where it's at right now, but without even that little box up. That box only has witnesses' names on it anyway. So, okay, and then you can just tell me that wasn't doing it at all. Okay. Jill is. Can I, my fear, Nick, is that this is going to block me. Okay. You can't get the feed of Nick with that.
Because I just unplugged mine so you could have it up.
Okay, ask me this again. What do you want? If you're doing what?
If you're showing a map or anything, could you have it up right in front of the bench by any chance, or is that too hard?
I feel like that's a Nick question. Two questions. Do we have an electronic copy of these exhibits? And his question is because he can't get a certain feed, he'd rather it go on that side so he can get a picture of it.
Well, let's make it easier for him.
I don't know. Is that what you were asking? Tell him what you're asking so I can make sure.
Is if the poster board to be up there, so we should see how I could get it with the camera instead of trying to plug it into the TV for right now.
Will that,
Since the thing is, I'm
so that I could get this TV to work? Okay. Okay. We won't be using the feed and opening, though. I don't believe.
How much railing? Yeah, absolutely. Yeah, I could.
Underpaid.
jury, is that correct?
You can all be seated. All right, we're here in case number FECR 153477, State of Iowa versus McKinley Louisma. The state is present by Lynn County Attorney Nick Maybanks, First Assistant Lynn County Attorney Monica Slaughter. Defendant is present with attorneys Jill Eimerman and Matthew Moore. Welcome back, jurors. At this time, I ask that the state please read the charge and defendant's plea.
State of Iowa versus McKinley Louisma. Trial information. Comes now Nicholas G. Maybanks as prosecuting attorney, and in the name and by the authority of the state of Iowa accuses McKinley Louisma of the crime of count 1, murder in the first degree, committed as follows. That the said McKinley Louisma on or about February 17, 2024, in the county of Lynn and state of Iowa, did unlawfully and willfully kill Melody Hoffmanin with malice aforethought, willfully, deliberately, and with premeditation, and or while participating in a forcible felony offense of kidnapping, and or aid and abet another in the commission of the offense. At Morgan Creek Park, 7212 E Avenue Northwest, Cedar Rapids, Lynn County, Iowa, and or Lily Lake, 220th Trail and 38th Avenue, Amana, Iowa County, Iowa, in violation of section 707.1, 707.21a, Iowa Criminal Code. Count 2, kidnapping in the first degree, committed as follows. That the said McKinley Louisma on or about February 17, 2024, in the county of Lynn and state of Iowa, did unlawfully and willfully confine or remove Melody Hoffmanin from one place to another, knowing that he had neither the authority nor the consent of Melody Hoffmanin to do so, with the intent to secretly confine her or with the intent to inflict serious injury upon her. And as a consequence of the kidnapping, Melody Hoffmanin suffered her and serious injury. And/or aided and abetted another in the commission of the offense at Morgan Creek Park, 7212 E Avenue Northwest, Cedar Rapids, Lynn County, Iowa, in violation of section 710.1, 710.2 Iowa Criminal Code. Count 3, conspiracy to commit a forcible felony, committed as follows. That the said McKinley Louisma, on or about February 17, 2024, in the county of Lynn and state of Iowa, did unlawfully and willfully conspire with one or more persons with the intent to promote or facilitate the commission of a forcible felony by agreeing with another that they or one or more of them will engage in conduct constituting the crime or an attempt or solicitation to commit the crime and or agree to aid in the planning or commission of the crime or of an attempt or solicitation to commit the crime at Morgan Creek, 7212 E Avenue Northwest, Cedar Rapids, Lynn County, Iowa, in violation of Iowa Code 706.1, subsection B, 706.3, subsection 1 of the Iowa Criminal Code. To these charges, the defendant has pled not guilty.
Jurors, at this time, the attorneys will have an opportunity to make opening statements. In doing so, they may explain to you what they believe the issues in the case are and what they expect the evidence will show. The statements which they now make and the arguments that they will later make after all the evidence has been received is not evidence. and may not be considered by you as evidence. Also, any statements they make about the law is not to be considered as the law of the case. Since evidence often comes in piecemeal and out of chronological or logical sequence in the trial of a lawsuit, the statements of counsel are merely to put the facts in perspective. They're intended to give you a thumbnail sketch of the case and outline the evidence to better aid you in understanding the issues and the evidence. And therefore, I ask that you give them your attention. The state will give their opening first, followed by the defense. Mr. Maybanks.
Thank you, Your Honor. Depraved, dehumanizing, defies reason. The evidence in this case will show that the defendant's actions, along with his accomplice, Dakota Van Patten, on February 17th into February 18th, 2024, were depraved. The evidence in this case will show that they kidnapped, killed, and mutilated Melody Hoffmanin in a manner that can be described as nothing less than dehumanizing. The evidence in this case will show, and we will lay out for you at the end of this case, multiple possible explanations for why he did this, but all of the explanations will defy reason. Depraved, dehumanizing, defies reason. The evidence in this case will show that on February 17th, 2024, Melody Hoffmanin was a young and vibrant 20-year-old lady. She was still finding her way in the world. The evidence will show that she lived with her mom and her protector, Megan Hoffman. But the evidence will show that she was not your typical 20-year-old young lady. Melody also had an intellectual disability. Melody had the mind and maturity level of a much younger person and processed the world more like a 12 or 14-year-old girl would. As the evidence will show in this case, because of who she is and what kind of person she was, she did not always make decisions that were in her best interest. Melody was more susceptible to manipulation. And the evidence will show she just wanted to feel loved and included. At the time she was killed, Melody was still at home, living with her mom, while many of her peers from high school had begun to move on with their lives. The evidence will show that Melody was very social, that she craved attention. But besides her family, there just weren't a lot of other people in her lives. In particular, she craved the attention of young men and really wanted to have a boyfriend. The evidence will show the defendant, Mr. Louisma, knew Melody very well as of February 17th and 18th of 2024. He had been in a relationship, even stayed with her at her home with her mother on occasion. But the relationship failed, and the two of them broke up around the beginning of the year 2024. The defendant would promise her that he was coming over and that they could hang out, but that he'd make excuses and not show up. The evidence will show the breakup was hard on Melody, and she didn't take it very well. You see, the defendant was her first real boyfriend. She wanted to be with him, but she couldn't stay with him because he wasn't valuing her. The evidence will show the defendant, Mr. Louisma, had a lot going on in his life when this happened. He had been involved in a longer-term relationship with another young woman, Nakia Sloboda, which had gone on for approximately 4 years up to that point. There had been some struggles and strife in their relationship, and the two of them split up in the middle of 2023, which is approximately the time he began seeing Melody Hoffman. The evidence will show the defendant and Nakia then reconciled and were back together around the same time his relationship with Melody Hoffman was ending. The evidence will show the defendant was living with Nakia, but had some struggles maintaining employment. And to top things off, Nakia was pregnant with this child. Both of these women knew about the other. And the evidence will show that the woman with which he had the longer-term relationship and commitment was Nakia. And she told the defendant he had to choose between her and Melody. The evidence will show there was a lot of stress going on in the defendant's life. A pregnant girlfriend and an ex-girlfriend, Melody, who still wanted to be in his life, with a secret of her own that was discovered after she died. You will hear the defendant's girlfriend had pregnancy complications that day on February 17th, 2024, adding to his stress. The evidence will show that this triangle, although certainly not unique, was extraordinary in the consequences that resulted from it. On February 17th, the evidence will show the defendant had a past with Melody Hoffman, but she wanted to have a future with him. The evidence will show he didn't. The evidence will show the defendant knew Melody well. He knew she would be willing to get into a car with him and another man, one she didn't know and who didn't know her, Dakota Van Patten. And that she would do so even though she had just broken up with him and there had been conflict between them. The evidence will show that he knew she would make that decision, which would prove to be her last. The evidence will show that Megan Hoffman, Melody's mom, was alerted to Melody's departure from their residence through a camera at approximately 11:24 p.m. on February 17th, 2024. Megan immediately reached out to her and asked her what she was doing and told her to hurry back home. You will see the conversation between Megan and Melody when she left the residence, which would prove to be the last time she saw and talked to her daughter. The evidence will show Melody Hoffman never came back home. In this case, ladies and gentlemen of the jury, through testimony, cell phone location data, cell phone forensic information, video surveillance, physical evidence, and even DNA evidence, the state will lay out to you exactly where Melody Hoffman traveled with these two men, the defendant and Dakota Van Patten, and what happened during that fatal car ride. But before we do that, the state will present to you what the defendant, Dakota Van Patten, and the third man, Logan Kimpton, did prior to picking up Melody. The evidence will show that a couple of days prior to this incident, the defendant had purchased a machete from Walmart and had been researching various face coverings and face masks. You will see on surveillance video the defendant, Dakota Van Patten, and Logan Kimpton, the third man, purchasing machetes and gloves at Walmart on the southwest side of Cedar Rapids just mere hours before the defendant picked up Melody Hoffman. And the evidence will show that it was not for the purposes of going camping or mudding in February of 2024. During this case, you will hear that Kimpton talked openly to others about the plan that he, the defendant, and Van Patten had. In this case, you'll be able to follow their actions as they came into contact with each other, proceeded to the Walmart on the southwest side of Cedar Rapids, and you will see that Kimpton then left the other men for the night, leaving the defendant and Van Patten together. The evidence will show they were together within an hour or so prior to picking up Melody Hoffmanin, when the defendant picked up another person, Trevor Weiss, from work at Lebowski's and drove him home. The evidence will show the defendant would later return to Trevor Weiss's residence after all this happened, tell him to tell anyone who may ask that he and Trevor were playing video games together all night. The evidence will show the defendant and Van Patten picked up Melody from her house. Initially, they were listening to music and driving around, seemingly having a good time. But that changed when they arrived at Morgan Creek Park in Lynn County. When they arrived at Morgan Creek Park, the evidence in this case will show that Megan Hoffmanin, the protective mom, was watching Melody's location and determined what she already pretty much knew, that Melody was with the defendant, because she knew they had been there before and the defendant's parents lived in that area. The evidence will show they drove to this dark and secluded park in Lynn County, and that's where this fun night turned fatal. The evidence will show that the carefreeness and levity of the night turned into depravity. The evidence will show that it was at Morgan Creek Park where whatever depraved plan the defendants had came into action. Melody was beaten. You'll hear about the blunt force of the beating she took when you hear from the pathologist who conducted her autopsy. While beating her, the evidence will show they used the handle of the machete across her face, just one of the weapons they ended up using. The evidence will show they terrorized and tortured her. They bound her hands and mouth with duct tape. You'll see what they did to her because it was documented. The evidence will show they tied her up and confined her within the car and then removed her from Morgan Creek, traveling back towards Marion to conduct whatever it was their sadistic plan. Whatever reason they had for this plan, for terrorizing, tying up, and then removing her from Morgan Creek, the evidence will show the reason was depraved and it involved dehumanizing her. The evidence will show they did not treat her as any human being would ever deserve to be treated, and that she endured unspeakable trauma before she was slayed, being subjected to severe physical and emotional pain. The state will demonstrate to you where they took her and what path they took doing it. The evidence will show they traveled from Morgan Creek Park back into Marion, nearly all the way back to her house. As they were heading back to her home to carry out their plan, if there even still was a concrete plan at that time, they stopped in a parking lot not far from her house. The evidence will show that Megan Hoffmanin was watching her daughter's location still, wondering where Melody was at and what she was doing. The evidence will show that Megan received a message from Melody on Snapchat, but the evidence will show that it could not have been Melody talking to her or messaging her at that time. The evidence will show was these men working in concert, in likely that it was the defendant directly communicating with Megan. You will see this conversation, and you will see that they indicated to Megan that Melody was nearby and heading home soon. The evidence will show that Megan demanded that Melody come home. And then the evidence will show in this case that the defendant and Van Patten encountered a Marion police car. And that at approximately the same time they did that, the location detection on Melody's phone was shut off and they left the area. The evidence will show that the defendant, Van Patten, and Melody Hoffmanin kidnapped, tortured, injured, and restrained, then traveled to Lily Pond in Amana, Iowa. Her final destination, the last journey of her life. The evidence will show that the defendant had intimate knowledge of Lily Pond and where it was. In this case, you'll see what happened next. And it will be shocking. And you might want to understand why it happened. But the evidence shows you, whatever reason it happened, defies reason. Because it was irrational, depraved, dehumanizing, and deadly. You see, the evidence will show you, and you will infer, that the defendants decided it had gone too far and they needed to end it. The evidence will show you they decided they needed to end their plan, whatever it was, end the activities for the night before they got caught, and end Melody's life. The evidence will show you when they arrived at Lily Pond, a place the defendant knew very well, the defendant and Van Patten strangled Melody with a paracord. The defendant and Van Patten stabbed her with a knife. The defendant and Van Patten slashed her back. The defendant and Van Patten mutilated her body. The evidence will show it was likely done to stage what her body would look like after being attacked. And if that wasn't the reason, the evidence will only be explainable by some other depraved and senseless reason, the likes of which reasonable minds could hardly construe. The evidence will show that the defendant, with Dakota Van Patten by his side, strangled Melody, stripped Melody, mutilated her body, and left her for dead on the shore of a chilly pond in rural Iowa County. And with that, the defendant also left behind, the evidence will show, at least part of the problems he was having in his life. 20 years of happiness, innocence, and zest for life gone within a matter of hours. The evidence will show there were different possible reasons why this happened. Animosity from the breakup, ridding himself of Melody so he could stay with Nakia and they could go on with their lives. Some kind of twisted plan that went too far. But the evidence will also show another potential motive. That could have been the sole reason, motive, on any other motive, or reasons we might not know and don't have to prove. You see, the evidence will show, and you will hear, that Melody Hoffmanin was either pregnant at the time of her death or had recently been pregnant. The evidence will show that at approximately 2:24 a.m. on February 18th, 2024, the defendant and Dakota Van Patten snuffed out Melody's life and left her body at Lily Pond. The evidence will show that while Melody lay lifeless on the shore of Lily Pond, the defendant and Dakota Van Patten got back into the car, listened to some music, traveled back into Cedar Rapids, bought some cigars, and then went home. The evidence will show the defendant dropped off Dakota Van Patten at the home of Taya Meyer, and that Dakota Van Patten had a conversation with Taya Meyer about what happened that night. The evidence will show the defendant went back home to his girlfriend, Nakia, kissed her, told her he loved her, sat down and looked at his phone. You'll hear what was found on his phone, and you'll see it as well. The evidence will show the defendant took one last look at what was on his phone and deleted it as if the subject matter never existed. The evidence will show that when Van Patten was dropped off that night and when the defendant went home, the defendant's car was also left on Hummingbird Lane in Hiawatha, where he was living. The car was seized, and the contents of the trunk of the cab of the car helped shed light on what happened to Melody and how the defendant and Van Patten conspired to kidnap her, did kidnap her, and kill her. What they found in the trunk of the car was deeply incriminating. What they found was a kidnapper's grab bag containing compelling and shocking evidence of the plight that Melody Hoffmanin endured at their hands. Her clothes with duct tape still on them. A paracord that was used to strangle her to death. A knife with her blood on it. A machete with a handle that matched the mark across her face. The evidence will show the defendant handled all of these items because he would admit to Special Agent Kedley of the DCI that he handled all of these items. And the DNA analysis of those items will also confirm they were used to kidnap and kill Melody Hoffmanin, that they were handled by Van Patten, and that they were handled by McKinley Louisma, as he admitted that he did. You will hear from Dr. Kelly Cruz from the Iowa State Medical Examiner's Office, who will explain to you that Melody died from strangulation, and that the ligature marks on her neck matched the paracord found in the defendant's trunk. The evidence will show the knife in the defendant's car that he admitted to having in his possession that night was also consistent with the stab wounds and slash wounds on Melody's body. The evidence will show these wounds were inflicted, likely, post-mortem. And you will infer that it was either done for staging purposes or for some unknown reason that, quite frankly, defies any rational explanation. The evidence will show she was strangled, stabbed, mutilated, stripped, and left face down on the shore of that pond. Dead at the hands of the defendant and Dakota Van Patten. At the end of this case, we will return to you, break down for you, nearly to the minute, proving to you each and every one of these facts that I've asserted to you are facts in this case, and demonstrate to you how the evidence in this case shows the defendant and Dakota Van Patten acted as primary perpetrators and as aiders and abettors to each other in the conspiracy, kidnapping, and murder of 20-year-old Melody Hoffmanin. And we'll show that to you to any doubt, beyond any doubt that is reasonable. And when we lay out for you the evidence in this case and the instructions that the court gives to you, we will ask you for verdicts of guilty to murder in the first degree, kidnapping in the first degree, and conspiracy to commit a forcible felony. Thank you.
Thank you, Mr. Maybanks.
Thank you, Your Honor.
Defense will now have an opportunity to give an opening statement. Ms. Emmerman?
On February 18th of this year, McKinley Louisma was at Morgan Creek Park, and he was at Lily Lake. He was there when Melody was beaten, and he was there when Melody died. However, this case is not nearly as straightforward as the state would lead you to believe. The state says frequently they. But there was no plan, ladies and gentlemen. There was no agreement. They were not acting in concert. There was no the defendant and Van Patten. Because while he was there, he did not strangle her. While he was there, he did not cut her. While he was there, he did not beat her. While he was there, he did not kill her. You heard that there were a number of items that were found in his trunk, and you heard that there will be DNA evidence about these items. And while McKinley may have said that he handled those items at one time, he did not use those items to kill Melody Hoffmanin. And what you will hear about the DNA that was found on those items is that none of the DNA belonged to McKinley. Among those items, there was DNA that could be matched to individuals. There was DNA that could be matched to 3 individuals. Those 3 individuals were Melody Hoffmanin, Logan Kenton, and Dakota Van Patten. This case, ladies and gentlemen, is not nearly as straightforward as the state would lead you to believe. And over the course of the next few days, you will hear from witnesses, and they will talk about the evidence that was found in this case. After hearing all of that evidence, after considering all of that evidence, you will determine that the state has come up short. That the state has not proven beyond a reasonable doubt that our client, that McKinley Louisma, is guilty of the charges that the state has alleged in this case. Thank you.
Thank you, Ms. Iberman. At this time, we will proceed with the presentation of evidence. Is the state prepared to offer its first witness?
Yes, Your Honor.
You may.
your right hand. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes, I do.
Have a seat if you would. And if you would please start by stating and spelling your full name for the record.
Amy Lynn Robas, R-O-B as in boy, A, S like Sam, S like Sam, E.
Good morning, Ms. Rodas. Could you first tell us just a little bit of background about yourself? Where are you from?
I live in the Amana area.
How long have you lived there?
4 years.
Where do you live?
I'm sorry.
What do you do for a living?
I'm currently not working due to medical issues, but until the beginning of this year, I was the executive director of a small nonprofit for people with disabilities.
Were you living in the Amana area on or about February 17th and 18th of 2024?
Yes, I was.
Do you remember what you were doing the morning of February 18th, 2024?
Yes, I do.
What did you do?
I went to Lily Lake or Lily Pond, depending on who you're talking to, and was sitting in the parking lot in my car, listening to an audiobook, watching the geese and the ducks, thinking about what I wanted to do for the day and some things that were going on in my life at that time.
Is that something you do a lot?
Yes.
And had you been to Lily Pond out there quite a bit in the past?
Yes, I usually go there a couple times a week at least, depending on weather.
What kind of area is it? It's out there.
Peaceful, sort of quiet. There's not much there except the lake, and there's a couple of picnic benches right along the shore by the parking lot, and a lot of people park there and walk the trail that goes around the lake. A few people will go and picnic there, but for the most part, people will park and do what I was doing and sort of sit and talk on the phone. I've seen a lot of residents sit and have lunch and just kind of appreciate the beauty of the spot while they're doing things that they need to do, sort of making their days a little bit better, I think, with that nice, pretty view.
Prior to today's date, did you see a picture of an aerial view of the Lily Pond area?
Yes, I did.
And if you saw that, would you be able to identify the area of Lily Pond and where it's located?
Yes, I would.
And was that a fair and accurate depiction of that area in your knowledge?
Yes, it was.
Your Honor, we move to the United States Exhibit number 2.
Any objection to Exhibit 2?
No, Your Honor.
Exhibit 2 is admitted.
And then when the court's able to request to publish that.
You may publish.
What are we looking at here in States Exhibit 2 initially here, Ms. Rojas?
An aerial view of Walford heading towards Amana.
Is that showing that, I think it's Highway 151 as it goes south through Walford to the mountains?
Yes.
If we could just go down to the bottom of the exhibit here. And down here in the bottom left corner of this exhibit, what do we see?
Lily Pond or Lily Lake, depending on who you're talking to.
Probably call.
That's usually how it goes.
And is that where you were at this location of Lily Pond in morning of February 18th, 2024?
Yes, it was.
About what time did you arrive that day?
Around 9:30.
When you arrived, was there anyone else there?
Not at that time.
Were you the only car there?
When I arrived, yes.
And while you were there, what did you do?
I was listening to my audiobook and just thinking and looking out the window.
While you were there, did anyone else arrive? In the area?
Yes, there were 2 other cars that came and sort of did what I was doing. They sat and they were actually on their phones and talking, and then left after a few minutes. And then I had a couple approach my vehicle on foot.
The weather conditions like that morning?
Overcast, kind of foggy.
When this couple approached you, what did they do?
They were acting strange. I actually felt really nervous seeing them because they were clearly agitated. They were older than I am and coming towards me, kind of waving. And so I rolled down my window and they were immediately asking for help. And so I ended up getting out of my vehicle to find out what was going on.
Did they direct you to a certain area in the park?
Yeah, they pointed towards the shore behind the picnic pavilion at the Lily Lake and said that they had been walking and saw something over there and they didn't know what it was, if it was a dead animal or if it was a mannequin or if somebody was playing some kind of prank, and would I go over there and look.
How long had you been there?
I would say I think I'd probably been there about 20 minutes.
And did you go out to that area to see what they were talking about?
Yeah, as soon as I exited my vehicle and started walking that direction, I was able to see that it was a human body and that it was not moving. And so I called 911 as I was walking that way.
About how many feet did you have to walk to be able to see that it was a human body?
I don't know that it was the feet so much as like there's a divot, the elevation changes a little bit where the body was, and so once I exited my vehicle, started walking, the way my line of vision changed, and then it was easy to see her, but that was probably about 10 feet from my vehicle that I noticed.
So were you unable to see this body previously just because of the way the area was landscaped?
I would say it was a combination of the landscaping and the fog. If I had, once I knew she was there, I probably could have seen her, but with the landscaping and the fog and just not expecting to see anything like that, it was not easy.
Now you mentioned that you called 911. We'll get to that in a moment, but as you approached this body, can you describe what you observed?
It was a young female. I could tell she had I knew she was young because she had the most beautiful, pale, perfect skin and glorious curls. And she was not moving in any way, shape, or form. She was not appropriately clothed. There were slashes and gashes all over her. her hands were curled in a way that they shouldn't have been.
As you approached her and observed her, could you tell whether she was breathing?
She was not breathing. I was fairly confident, just even from a distance, that based on positioning, the temperature, the way she was laying, not being clothed appropriately, that she was deceased.
And when you say she wasn't clothed appropriately, what did you see her wearing, if anything?
I know she still had underwear, and I believe she still had a bra. Honestly, I've tried to forget. I try not to think of her like that. But I remember also, her underwear wasn't on correctly, and so when I called 911, I also mentioned that I thought she might have been sexually assaulted.
What kind of position was she in?
She was laying on her stomach. I could not see her face.
Did that also indicate to you that it was likely she wasn't alive by the way this was positioned?
Yes, and I also saw wounds on her body that I thought might have been post-mortem wounds. There was no blood on them.
So you saw wounds in her body but no active bleeding?
It's what it looked like to me. I've never seen that in real life, but I've read about it.
Did you see anything else about her while you were observing her that thought maybe that led you to believe that maybe she did have some life in her?
When I was talking to emergency personnel, I noticed she had goosebumps, and I, at that moment, thought maybe I was wrong because she had goosebumps, so maybe she just was not well and really cold, and I told 911, and they said, no, don't, because I thought maybe they would tell me to go assess her, and they said, absolutely stay back, don't touch her, which I had not at that point, nor did I.
Did you later learn what those goosebumps may have been?
Yes, goosebumps can be an indication of rigor mortis.
Objection, competence, Your Honor.
Sustained. Jury will disregard the last answer.
Did you touch or disturb her body in any way?
No, I did not.
Now, when you saw this body, then you indicated that you made a phone call.
Yes, I did.
Can you approach the witness, Your Honor?
You may.
And the witness was being marked as Stacy exhibit number 4. And prior to today's date, Ms. Rojas, did you have an opportunity to review the 911 call that you made to the Iowa County Sheriff's Office?
Yes, I did.
Was that a fair and accurate recording?
Yes, it was.
Move to admit Stacy exhibit number 4, Your Honor.
Any objection to 4? No, Your Honor. Exhibit 4 is admitted.
Now I'm handing the witness what's been marked as Stacy exhibit number 5. Did you also end up receiving a phone call back from 911 to gather more information?
Yes, I did.
And have you had an opportunity to review that prior to today's date?
Yes, I did.
Was that also a fair and accurate recording?
Yes, it was.
Move to enter State's Exhibit number 5, Your Honor.
Any objection to 5? 5 is admitted.
Permission to publish those exhibits, Your Honor.
You may do so.
Thank you.
I'm actually at Lily Lake in Amana, and it looks like a dead body here. I'm with a couple other people. They said, don't turn on the sirens.
Okay, you're at the Lily Pond?
Yeah, right by where the picnic area, the pavilion is.
Okay.
The woman, and she's just wearing underwear.
Is she breathing?
It does not look like it.
Do you see her chest rising and falling?
She's on her back or on her stomach.
Okay. Do you see any?
I
don't want you to touch her.
No, none. And there's a bunch of like welts and marks on her, and she looks stiff. But she does have goosebumps. I don't know.
What's your name?
Amy Robas.
Can you spell the last name?
R-O-B as in boy, A, S like Sam, S like Sam, E.
And phone number, Amy?
39217-2866.
Okay, I'll get somebody over there, okay?
Yeah, thanks.
Okay, yep, bye-bye.
Hello.
Okay, Amy?
Yes.
This is Sarah with the Iowa County Sheriff's Office. I've got an ambulance
Yes.
on the way, and I've got some deputies on the way. Where exactly are you
Okay.
guys at the Lily Lake?
We're sitting at the pavilion,
And how
and the
many
body
people
is, there are 3 of us. There were 2 people walking, and I was actually just sitting in my car looking at the birds, and they came and grabbed me because they weren't sure if it was real, and so we're all sitting here together.
Okay, just a minute.
They are.
Okay, so you said that she's on her stomach?
She is on her stomach, yes.
Does it look like she was in the water?
No.
Okay, and is there anything else around her?
No, but there are all kinds of marks on her back, like flashes.
Okay. Okay,
I'm wondering if there might have been a. No, we're not. We're not over there anymore. I'm wondering if there might have been a sexual assault too.
Okay. Like I said, I have deputies on the way. If you can just
Okay. Yep, we're waiting.
away from her, but if anybody does go up to her, just tell them to get away, please.
Yep. And there's nobody else here right now. We're hanging out waiting.
Okay. Thank you, Amy.
Okay. Yep. Bye-bye.
Ms. Robas, then did you remain on the scene there at Lily Pond until law enforcement and medical authorities met?
Yes, I did.
And while you were waiting their arrival,
No, it was not.
Did you remain on the scene long enough to provide your name and information in case you needed to write it down?
Yes, I did.
No further questions, Your Honor.
Cross.
Thank you. Good morning.
Good morning.
Ms. Robas, do you recall what the temperature was that morning?
No, I do not.
You referenced noticing goosebumps, is that right?
Yes, I did.
That stood out in your mind that day?
Yes, it did.
You mentioned it today in your testimony. When you went home that day, you got on the internet, didn't you?
Yes, I did.
Some of the observations that you'd made led you curious to learn more information, is that right?
Yes.
And so, for instance, you got online and you did a little bit of research on the internet about goosebumps, is that right?
That's correct.
But you're not an expert in that area, are you?
Absolutely not.
And you mentioned your observation of the knife injuries being possibly post-mortem, is that right?
Correct.
That is in no way an area of your expertise, would you agree?
Absolutely not, no.
You're just kind of guessing.
Correct.
That's okay. I appreciate it. You've answered my question.
Yeah.
I don't have any other questions. Thank you, ma'am.
Okay, thank you.
Redirect.
Nothing, Your Honor. Thank you.
Right. Thank you very much. You're excused.
Thank you.
Is the next witness likely to be a short witness or a long witness? Longer. All right, let's go ahead and take a morning recess then. We're going to be in recess for about 15 minutes. Jurors, have a good break. Please remember the admonition I gave you before. We'll see you back shortly.
with us in just a second. I have worked on a version based on what Mr. Abadi sent, but I'll obviously look at yours as well. Okay, so that's one thing. Then we have our witness list for the truncated week. There's a motion to limit autopsy photos. I guess this is from the drinks. Shooting, and then there's a motion to prohibit recall of Detective Thorpe, which I actually haven't even had a chance to read yet, but if either of those is not opposed, then we can handle those in short order. And then with regard to, you know, when we actually left the jury last over a week ago, counsel for Mr. Nichols had moved for a mistrial, and I had denied a mistrial with prejudice. But inquired as to whether she was interested in a mistrial without prejudice, and of course that issue is now moot. And I don't know what anybody who's still here's position currently is with regard to whether they feel any entitlement to a mistrial without prejudice, but I will hear from counsel for Mr. Kendricks and Mr. Stillwell as to that issue.
Mr. Kendrick is not interested in a mistrial without prejudice, Your Honor. So if that's not going to be granted,
all right.
One with prejudice is not going to be granted. We're not interested in without prejudice.
All right. Well, have y'all moved for one with prejudice with regard to
what
our last issue was?
I believe under the Harvey rule that all of us had joined that unless we specifically opted out.
All right. Okay. Well, that had been denied. So if there's nothing else with regard to that, y'all do not want one without prejudice. All right. How about you, Mr. Short, on behalf of Mr. Stillwell?
Good morning, Your Honor. We are in the same position. We are not moving for a mistrial without prejudice.
All right. Well, that takes care of that issue. How about let's look at our list of witnesses for the week. There are, thank you, she brought it down to me, 3 witnesses who it is proposed not be shown on camera, and I believe the reason provided for that was each of those witnesses works in an undercover capacity. Is that right?
Yes, Your Honor.
Okay. Any objection on that?
Mr. Kendrick only objects to investigator, I believe it's Stark or Starks, just because I'm not sure why they should not be shown when they're featured on the Facebook page of the APD throwing a football and their image is shown. So I think if there was a concern about not showing that particular witness they wouldn't be publicizing his face on Facebook.
Well, it may be that their face had not been associated with their name, which is no longer the case.
Well, no. It features his name.
Ah,
I wouldn't have said it otherwise, Your Honor.
okay, appreciate that. Is that the case?
Your Honor, he also works in the same unit as Investigator Flores.
Is that on?
It's not okay. As to that investigator, Your Honor, we were unaware of that until this moment, so we're going to look.
All right, well, y'all check on that. That seems like a pretty valid objection, and no objection with regard to the other two. So we can circle back on Starks. He wouldn't be called until later in the week anyway. All right, that takes care of that. Ms. Percival, Mr. Weinstein said that they had also reported around 10 p.m. last night, a proposed jury instruction.
Every ruling is different, but based on Your Honor's previous rulings, that would have been outside the scope of cross, or outside the scope of cross for them to get into that on redirect. And it just seems to me simply recalling him is just an end around of that rule that we've been abiding by.
All right, let me hear from the state on this matter.
So, Your Honor, with Detective Thorpe, he's going to be covering three, I'll call it categories of testimony. For one, he is going to be discussing Defendant Kendrick's statement to law enforcement that was pertaining to the Donovan Thomas murder. Also, Detective Thorpe was the lead detective, homicide detective, on the March 11th, 2022 murder of Christian McMiller and Darius Ford, which, as the state has articulated to this court before, is intrinsic to the Chamel drinks because it leads up to that murder.
Yeah, and I don't think the objection is as to that. So what's the third?
So, Your Honor, third is that the questioning, because Detective Thorpe is going to be testifying about those first two, the state's questioning of Detective Thorpe in relation to Defendant Stillwell's statement, I would proffer would be 15 to 20 minutes. The state intends to ask Detective Thorpe questions, not play the statement, which alleviates need for fights over redactions or playing to the jury. So in the state's legally, the state is calling a witness to testify about relevant admissible evidence, specifically two statements of party opponent. And so the state feels that there's not a valid legal objection to keep out relevant admissible evidence. And the state also feels that Detective Thorpe is going to efficiently cover three topics which could be different witnesses.
Okay, but with regard, I don't think the issue is as to the other two. It's as to talking to him about Stillwell's statement from
All right, we're back on the record. FECR 153477. Is the state prepared to call its next witness?
Yes, Your Honor.
You may do so.
State calls Mark Teat.
Okay, please raise your right hand. Do you swear affirm to tell the truth, the whole truth, and nothing but the truth? I do. If you would please state and spell your full name for the record.
My full name is Mark James Teat. First name is M-A-R-K. Middle is James, J-A-M-E-S. And Teat is spelled T-I-E-D-T.
Thank you. Go ahead, counsel.
Thank you, Your Honor. Can you start off by telling us how you're employed?
I'm a deputy sheriff with the Iowa County Sheriff's Office.
And how many years of service do you have with the Iowa County Sheriff's Office?
I've been employed there since June 1st of 2006.
Are you a graduate, or did you graduate from one of the Iowa law enforcement academies?
I graduated from the 205th Basic Academy in July of 2005 at the Iowa Law Enforcement Academy.
And so does that make you a certified peace officer in the state of Iowa?
It does.
And you said your current position is deputy sheriff?
Correct.
Have you held any other positions through the Iowa County Sheriff's Office?
I was a canine handler for several years, but still a deputy sheriff during that time as well.
How many years were you a canine handler?
Approximately 7.
And did you have any law enforcement experience prior to becoming employed with the Iowa County Sheriff's Office?
Yes, ma'am. In 2005, I was employed with the Marion Police Department, and then I left there in October of 2005, approximately. I went to work for a family business, and then in 2006, I decided to get back into law enforcement. I worked briefly for the small town of Tripola Police Department, and then I got hired by the Iowa County Sheriff's Office.
And deputy sheriff, was that the position or the title that you held back in February of 2024?
Yes.
Can you tell us briefly, as a deputy sheriff, what your primary job duties or responsibilities are?
Mine differ a little than a normal deputy. I'm a patrol, primarily patrol, but I also assist with investigations when our primary investigator is overwhelmed or his caseload is too much or he's not available. But primarily it's patrol. You drive around, deter crime, traffic enforcement, answer calls for service, that type of thing.
Counsel, would you turn your mic on?
It is.
Oh, somehow it's not coming through well.
Will you
I'll turn it up.
Thank you. How's that, Judge? Better?
Better, thank you.
Yes. Deputy, on February 18th, 2024, did you become involved in a homicide investigation of Melody Hoffmanin?
I did.
And can you tell us how it is you became involved in that?
I was working just a normal patrol shift that day, and it was probably about 12, I think I have in my notes, in the morning. Iowa County Dispatch received a 911 call of a female that had been found at the Amana Lily Lake, and the caller believed that she may be deceased.
When you work patrol, are you patrolling the entirety of Iowa County?
Yes, all approximately 600 square miles.
Can you recall approximately where you were when this call came out from dispatch that this body had been found?
Actually, I was at the office. I was in Marengo at the time.
And so once that call came out, did you head straight towards the Lily Pond or Lily Lake area?
I did.
And just to be clear, Lily Pond and Lily Lake, are those used interchangeably?
Yes, it's very common to call it either one.
Okay. The information that comes in through dispatch, does dispatch then relay or tell you that information as you're responding? Aerial photo of the Lily Pond area?
I do.
When you arrived at the Lily Pond area, which way did you come in from?
I would have came from the west traveling east. So this is 220th Trail here, and this is the direction I would have traveled, eastbound on 220th Trail to the Lily Lake, to this area right here.
And is that at the area of the pond at the kind of center top of that pond area where the pavilion is located?
Yes, so this area right here, this would be the parking lot to the pond, or to the Lily Lake, and then the pavilion would be right in here.
Thank you, Your Honor. When you arrived at that area, did you make contact with anybody?
I made contact, yes, with 3 individuals, and then also I believe there was 2 QRS or first responders on scene already.
Okay, so the 3 individuals that you made contact with, do you recall their names?
One was Amy Robasi, and then I have Ursula Williams, and then her husband, Scott Williams, maybe. Yes, Scott Williams.
Was Ursula and Scott the older couple?
Yes.
That was there with Amy Rabas?
Correct.
Okay. You also mentioned that there were QRS members that were present. What's QRS?
In Iowa County, QRS is called Quick Responders. It's an acronym. And QRS is basically your first responders. So every town has volunteer service first responders. And this was called out as a medical call originally. So they dispatched an ambulance, but then they also dispatched first responders because the ambulance cannot get there as quick as first responders can.
Okay. And so these first responders have some degree of medical training or paramedics or something?
Yes.
Okay.
This was, yes.
And did they check Melody Hoffmanin for signs of life?
The one female member named Madison Frame did inform me she checked the Miss Hoffman for any heartbeat or anything like that, and she said she did not.
Medical personnel to arrive and make contact with the injured or deceased individual before law enforcement gets involved?
It is very common.
So after it was relayed to you or conveyed to you that Melody did not have any signs of life, what did you do next?
I went over and observed Miss Hoffman lying in the grass, and to me, obviously, she was clearly deceased as well.
When you say you observed her, can you describe for us what your initial observations of Melody Hoffman were?
So she was lying face down on the ground. Her head was to the east, her feet were to the west. Her arms were down to her sides, kind of spread out a little bit. I would say her hands were 2 or 3 feet from her body. She had all kinds of lacerations across her back and then some stab wounds on her back as well. Her underwear was pulled down over her buttocks, and then her bra had been pulled up towards her shoulders. She was not wearing any other clothing besides that.
Deputy, can you recall, or would you describe this crime scene as particularly bloody?
No, there was very little blood, actually. Ms. Hoffman had a little bit of blood, but there was no blood pooled anywhere on the ground. To me, it was almost as if that's not where the scene occurred, the actual homicide occurred, because there was no blood anywhere, really.
Did you touch the body?
I did not. I did touch her body after the special agent with the DCI arrived and after the medical examiner. But prior to that, no, I did not touch her body.
So well into the investigation?
Yeah, yes.
Okay. At the time that you are there and making your initial contact, had this body in any way been identified?
No, it did not.
And so you noted that the medical examiner and you said an investigator, did they touch or manipulate the decedent in any way?
After they arrived on scene, yes. They did. We did move Ms. Hoffman to where we could take photos of her and examine her. But until then, no, Ms. Hoffman had not been moved.
In the course of events or the chain of events that occurs, photographs overall are taken, is that correct?
Correct.
Was the area and the condition of Melody Hoffman's body photographed before she was moved or manipulated in any way?
Yes, I did photograph the scene along with the body.
Can you recall approximately what time Melody Hoffman was confirmed deceased?
It was at 10:37 a.m.
Was the scene taped off?
Yes, it was.
Explain to us what it means to tape off a crime scene.
This area was rather large due to the open area, but basically we put crime scene tape, secured the parking lot. We put crime scene tape along the bike trail, and then to the east of the pavilion, there's actually a small bridge. We blocked the scene at that bridge with crime scene tape. And then we just basically kept everybody out of the scene that had no business to be in the scene. If someone had pulled into the parking lot, we politely asked them to leave the parking lot. We basically just kept everybody away from the scene.
How is it determined how big of an area to tape off when you're taping off a scene?
At this scene, we just started taping, actually. We just tried to get as much area as we possibly could taped off.
And though it may seem obvious, can you explain to us the purpose of taping off a scene area?
Just to keep the public and keep anybody outside that doesn't belong in the scene, to keep them outside of the scene and to preserve any evidence that is inside the scene.
So it limits contaminating the area?
Yes.
Okay. Once that area was taped off, did yourself and other law enforcement officers begin processing that scene?
We did.
And can you tell us what's the first step of processing a crime scene?
Photographing it, and which is what we did immediately.
When a crime scene is photographed, are there just numerous photos that are taken?
Yes.
And during that photographing process, was Melody rolled over so that her body could be photographed from all angles?
Ms. Hoffman wasn't rolled over until the medical examiner arrived, at which point we did roll her over. But yes, it was photographed after we rolled her over.
Once Melody was rolled over, did you make any additional observations that were relevant or pertinent to your investigation?
We observed more injuries on Hoffman.
What were the extent of those injuries?
You could see that where She appeared to almost have been strangled, like ligature marks on her neck and markings on her wrist and ankles as well.
Do you recall seeing any injuries to her face?
I'm just trying to think. If there was, they're not sticking out to me.
Okay. In the position rolled over, face up, do you recall seeing any blood?
If there was, it was very little blood, nothing that would stick out to me as being a large amount of blood.
Were there any evidentiary items that were located near or around Ms. Hoffman's body?
So we found a necklace that was laying near her, and we also found a piece of pink cloth that was laying near her. And I believe we found a cigarette and a blister pack for a pill. I don't believe we gathered those as evidence. I don't know if those had anything to do with the case or not. But those are the four things that stick out to me.
The necklace that was found, was she wearing that necklace?
No, it was laying on the grass next to her.
Do you specifically recall any pieces of jewelry being worn by Melody?
Ms. Hoffman did have a class ring on her hand.
Deputy, I would like to show you what have previously been marked as States Exhibits 6A through 6U. Are they on your screen, Judge?
Yeah, just on your screen.
Do you recognize these photos?
Yes, I do.
And are they photos that were taken at the scene at Lily Pond?
Those are all photos that I would have taken.
Okay. Your Honor, the state offers 6A through 6U.
Any objection to Exhibits 6A through 6U? No objection. Exhibits 6A through 6U are admitted.
And may I have permission to publish photographs, Your Honor?
You may do so. Tell me when you're ready.
I'm ready when you are. Deputy, starting first with States Exhibit 6A, can you tell us what we're seeing in this photograph?
So this area here would be the parking lot to the Lily Lake. This is a bicycle trail that goes all the way around the Lily Lake. This would be the pavilion, the picnic area for the Lily Lake. This is the shoreline, and right there is going to be Miss Hoffman's body.
And in States Exhibit 6B, can you tell us what we're seeing in this photo and from what vantage point?
So here, I'm actually going to be to the east of Miss Hoffman, looking back to the west. This is going to be Middle Amana, and this is going to be the Lily Lake. The pavilion would actually be over here on your right. It's out of the photo, and then there again is Miss Hoffman's body.
And 6C?
I'm actually going to be looking south across the Lily Lake, or southwest across the Lily Lake. This is going to be Whirlpool Manufacturing back here, the Lily Lake, and then this is going to be the shoreline. So I would actually be standing about where the pavilion, or right in front of the pavilion is where I would be standing.
When photographs are taken at a crime scene, is there an approach to taking those photographs where you start from a distance and work your way in?
Yes, so this one I did. I started from a distance. I took photographs of various angles, and then I slowly worked my way into the body.
What's the purpose of that?
Just to try to catch any evidence that you may see, further away or further closer, just more to look for different types of evidence.
Does it also assist when you go back and look at photos to give you perspective on where things are?
Absolutely.
Okay. 6D, what are we seeing here?
You're going to see Miss Hoffman's body. I would actually going to be to the northeast of her, looking at her body, and then this is going to be the shoreline to the Lily Lake right here, and then obviously the Lily Lake.
And 6E?
We're moving closer into Miss Hoffman's body. These items here, these are actually monitor pads that the ambulance put on her. But then we're just moving closer. So I'm standing to the east of her, taking a photo of her facing more to the west.
Can you tell us what we're seeing in 6F?
Yes, so this is just an overall view of Miss Hoffman's back and the slashing marks. And she does appear to have some stab wounds, these 2 stab wounds here. And then there's this piece of pink cloth down here that we did gather as evidence as well.
The condition of Miss Hoffman's undergarments, is this the condition that she was found in when you arrived?
Yes.
And the position of her body, was this the position that she was in when you arrived?
Yes.
And again, these blue and white items, one on the right shoulder, on the right rib area, and up on this shoulder, those were placed there by medical personnel?
Correct.
(6G).
Once again, it's just another overall view of Miss Hoffman, just from a different side.
From this angle or from this vantage point, were you able to observe?
Yes, here would be another one. So you have there's 1, 2, 3, and 4. And then those would be what I would consider a stab wound.
6H.
Just a close-up imagery of her back.
And though it may seem apparent, these straight linear marks on the body, those defects, were those wounds or injuries as well?
Yes, to me it would almost be like a slashing or a chopping or cutting type injury.
And earlier when you referred to slashing injuries, were these the injuries that you were referencing?
Yes.
(6I).
Point, we're just taking photos of the stab wound here and using a tape measure for reference to show the size of the actual wound.
And so that tape measure gives you perspective on the size of that stab wound there?
Correct. And the same one here as well, just using the tape measure to show perspective of the size of the injury.
In 6J, because we're zoomed in, it's difficult to tell which part of the body this is. The black item here, is this the bra or underwear?
That would be her bra.
And 6K, what are we looking at here?
This is going to be her right hand. And the reason I took this is that the cuts on her fingers to me would almost be like a defensive injury, where she was holding her hands up or something. But the primary focus of this photo would be the cuts on her hand right here.
6L, what are we seeing in this photograph?
That is just going to
that was on Melody Hoffmanin when you came into contact with her. Is that ring present in 6L?
I believe that is the ring, yes.
6M, can you tell us what we're focused on in this picture?
It's kind of hard to see, but there's actually the injuries on her ankles here. And then,
will you dim the lights for me, please? Does that help?
That does help. Thank
Okay.
you. The injuries to her ankles here, and then also you can almost see as if these lines here, and that's what we are focusing on.
What did those lines that you're referencing indicate to you?
To me, I mean, as if maybe her ankles had been bound at some point.
6N, can you tell us what we're seeing in this photograph?
That is just a homemade tattoo of a heart. I believe it's a heart. We used that, we photographed that because at this point in the investigation, we still had not identified her. So we were taking photos of any type of tattoos or anything that could help identify Ms. Hoffman.
Were there any injuries that you were able to also observe in the photo of 6N?
Yes, there's going to be these injuries right here around her hands. That to me appeared to almost as if her arms had been bound, her hands had been bound as well.
The darker mark just above that tattoo that you referenced, did that appear to be an injury, or was that just...
Yes, ma'am, that's also an injury.
What are we seeing in this photograph?
Here again, the injuries to the hand, and then to the arm and wrist, and then also the tattoo of the heart. But these are the injuries right here.
So this is the same arm, wrist area that we saw in the previous photo, just from a different angle of the arm.
Yes.
6P, tell us what we're seeing in this photograph.
That is going to be the class ring that ultimately we used to identify who the female was.
And can you tell us how that ring was used to identify her?
Yes, so once we took the ring off, on the inside of the ring was the name engraved of Melody Hoffmanin, and we performed a record search through the Iowa driver's license system, and we were able to obtain a photograph of Melody Hoffmanin, and that is how we identified her.
(6Q), what are we seeing here?
This is going to be Miss Hoffman after we had rolled her over. This is just an image of her face.
Is there anything, well, what we see in the nose area, would that be blood?
That is a little bit of blood there, yes.
You also testified for us, Deputy, that when you rolled her over, you were able to observe additional ligature marks. Can you tell us where you saw those?
So they're actually going to be right in this area here. Here's a small one of them. I believe there should be more photos where I actually move her head a little bit and you can see those markings better.
And is that what we're seeing in 6R?
Yes, it's going to be these marks right here.
6S, tell us what we're seeing in this photograph.
That is going to be this small piece of pink clothing that I pointed out earlier. This is going to be her right breast, and then this is going to be her right arm.
In this photograph, is she still in a face-down photo?
Yes.
And so when you see this and photograph it, is it also something that's collected from the scene?
Yes, that piece of pink clothing was collected.
(6T) is a little difficult to see, but can you tell us what we're focusing on here?
Yeah, right here, it's very hard to see, but this is actually the necklace that we recovered at the scene. Here's one piece, one end, and then there's the other, and it goes in this shape right here. But that is going to be the necklace that we collected at the scene.
6U, is that the same necklace?
That is the same necklace. At this point, we had picked it up. I laid it on the paper bag and photographed it just so that way it could be seen better rather than in the grass.
While at the scene, did investigators add anything to her body?
No. We did put paper bags on her hands, but that was the only thing we did to the body.
Tell us why paper bags are put on hands at crime scenes.
To preserve any type of evidence that may be under her fingernails, any DNA evidence, also preserves any markings that would be on her hands or anything like that.
And so the paper bags that are put on the hands, do those paper bags remain there until the time of autopsy?
Yes.
Can you tell us, once the scene was, the processing of the scene was completed, what happened to Melody Hoffman at that point?
She was transported to the state crime lab in Ankeny for an autopsy.
And the state crime lab in Ankeny, is that typically where autopsies are performed?
For our agency, yes.
Once the scene was cleared, Ms. Hoffman removed, did you perform any canvassing in the area?
I did. I went to spoke to a couple of the individuals that actually live across the Lily Lake in the middle Amana side.
And when we use the term canvassing, what's that mean?
I knocked on a few doors and just asked them if they noticed anything throughout the night or early in the morning that would be suspicious or that might raise alarm to them.
Through your canvassing efforts, was there anything that you gained that was important to your investigation?
No, nothing super important. The only one was I had spoken to an individual named Dan and Angela Ray, and they informed me that they are
Objection, hearsay?
Sustained.
The information that you got from the Rays, did you do anything with that information?
No.
Okay. So after having received it, did you make a determination that this wasn't essential to your investigation?
Correct.
Okay. I don't have any additional questions for this witness, Your Honor.
Cross?
No questions.
Thank you, Deputy. State can call its next witness.
State calls Corey Grote, Your Honor. I thought he was at 11. Okay. May we approach, Judge?
You may.
Sorry.
All right, jurors, I'm told that our next subpoenadness is not subpoenaed until 1 o'clock. So we're going to take our lunch early today. Instead of lunching from 12 to 1:30, we're going to go from 11:30 to 1. And so I'm going to recess at this time. Please remember the admonition I've given you. We'll see you back at 1 o'clock. Have a good lunch.
Zayden Ali. Zayden O. Ali. Alex Mielsek. Juan Aribi. By Zoom. Okay. For Juan Aribi? Yes. All right. Crystal Molina. Jordan Davis. Daniel Guerrero. Brennan Short.
She's in federal custody.
All right. All right, there should be no one on the front row unless you're late. Domingo Rodriguez, custody. Hassan Kadir. Good morning. Isidore Heredia. Heredia. Custody. Thank you. I'm working on my R's. That's going to be my birthday gift to myself. I'm going to work on my Spanish R's. Marco Calendres, custody. Dirkland Davy. Roberto Andrade. Edgar Aguilar, custody. Sarah Gutierrez. Thank you. Arita Maldonado. Catherine Aguilar, custody. Ortillo Espinoza Ruiz. Darren Johnson.
Present, Judge Boyd.
Thank you. Curtis Wilson, custody. Mariah Lopez. Custody. Kevin Wright, custody. Elisa Hernandez, custody. Thank you. Is there anyone who's present and your name was not called or you came in late? Anyone? All right, and you need to remove your hat? Yes. Your hair is beautiful. I always tell people, you know, beautiful. All right. But if you feel more comfortable with your hat on, you can wear it, but your hair is beautiful, okay? You're welcome. All right, everyone. Oh, they're with you? Oh, they're with you? Okay, thank you. All right, everyone, these are the rules of the court. Please follow these rules because as you can see, this is a Monday. We want this Monday to be a great day because guess what? We're currently alive, so that's something to be happy about. So in order for this machine to run smoothly, sympathetically, empathetically, and humanely, everyone needs to follow these rules. Attorneys, listen to me carefully. If you have a client who's in custody, request that your client be brought out by the deputy. Your client needs to be brought out, whether you're getting a reset or not. So there's no need to talk to the coordinator, the clerk, but I'm just getting a reset because you don't know if I'm going to give you one or not. Number two, once you requested your client, do not leave the courtroom. We have a limited number of deputies. We have a lot of inmates, and for security reasons, only so many inmates can be in the box per deputy. So if you leave after requesting your inmate, you're being selfish to your colleagues. If your client wishes to speak to the court in a language other than English, We will need an interpreter, whether you speak the language or not. Again, ask the clerk or the coordinator, let them know you need an interpreter. Once you've requested an interpreter, do not leave the courtroom because we have a limited number of interpreters. Do not approach the clerk. Do not approach the coordinator for a reset or a continuance or to be excused. I'm the only person who can do that. The court reporter is here. I say this all the time, but for my birthday, this is what I want, or should I say birth month, because I celebrate the entire month, as everyone should do. This is what I want you all to give me for my birthday. When we are on the record, do not approach the clerk or the coordinator, and do not stand behind the court reporter. Do not talk in the box behind the court reporter because it makes it difficult for her to hear. And please do not gather around the court reporter and place your items on her desk. Can you imagine if you're at your office and somebody just starts standing around you and talking around you? It doesn't feel great. So that's what I would like for my birthday, for everyone to follow those rules. Someone is going to jury trial today. So if you're working out an agreement, it needs to be done today, and it needs to be done with haste because we're calling up a panel and someone is going to jury trial today. Criminal Trial Division, they are there with their files. Family violence are with their files there. Here's another birthday gift I'm asking you for. If you all could please, because flu season, pneumonia season is on the uptick, if you'll just grab your file and place it on the desk, they're going to call you in the order of appearance. Just put it down there, have a seat instead of everybody rushing around the attorneys. Just do that. Guess what? Everybody has somewhere else to be. Everybody has something that's super important in their life. But if we do this, then we can move along swiftly and easily. All right? So I know everybody's going to give me those birthday gifts. I thank you in advance. Everyone, please confer.
Client house, as soon as she comes out, we're ready. Lisa, Hernandez.
All right, and Deputy Laura, could you bring out John Young's client?
Brennan Short. I think he was the very last person called today. Brennan Short. I think he was the last week on the docket.
Yes, sir. I don't know if
Okay, I'll ask.
Can I see the file on Catherine Aguilar, please? Yes. All right. All right, Brennan Short. Brennan Short.
Judge, he's in federal custody. May we approach the state?
Yes.
Tell me when you're ready, Your Honor.
Oh, I am ready.
Judge, the state has made me an offer this morning on Mr. Short. He's serving a very long sentence in federal custody. I don't know if the court would entertain bringing him back in absentia for a plea. I don't.
We can do that. I don't think they do Zoom. Normally, are they doing Zoom in federal? Yeah, they won't do Zoom. So if there is no objections, but you have to have the appropriate paperwork for him to plead in absentia.
Right. Right. So I guess. But if we can't do Zoom, then what are our alternatives? Just bring him
We
back
can
here?
have him bench warranted back.
Or
I've requested it back already, Judge, through ours, and I think also through, I don't know if we had to do it through. Okay, so I have an email, a note that I did request it from our clerk.
Okay.
And so it should have been requested the last time you were here. I don't know. when
well,
that
he's
was,
still
but-
where he's at. So.
Yeah.
All right, so let's do this. Let's recall it in December. And if he's here sooner than that, we
Sure.
can let you know, we can bring him back sooner.
Well,
So-
if he gets here sooner, I'm gonna come to court and ask for a date, so.
All right, so y'all want to try for December 9th?
That's fine, Judge. That's fine.
All right, Norma, on Brennan Short, we're going to put him down for December 9th. And can you check with the jail to see what the status is on his return? All right,
Thank you, Judge. Appreciate you.
If you get something on that, you let me know. Thank you.
Oh, excuse me, Pat.
Yes, ma'am.
Hi, could you all do an acknowledgement of discovery if that hasn't been done?
Yes,
Uh,
ma'am. I'll find
Okay.
Jason, you're good.
Tony, uh, could you do an acknowledgement of discovery on Brennan Short?
Yes, ma'am. I'll do it right now.
All right, thank you.
I could take you for coffee.
She's here.
They give it to us, but they're gonna take it away.
Go on, man. Half full, half empty. I don't even have a glass. Did you have brothers or sisters?
Yeah, two brothers.
Okay, well, when we were young, this joke would go around, but so we didn't have any money.
Mhm.
So we would like pick up soda bottles or whatever
We
we
did
could
that too, yeah.
and to share a soda.
Yeah. Oh, yeah.
So we would take them to this candy store
Mhm.
and get a soda.
Mhm.
And we'd say, well, half and half.
Mhm.
And so I said, well, if you don't mind, I'll go first.
Yeah.
I drank the whole thing. My brother said, Ed, what? We were supposed to split half and half. I said, yeah, but my half was on the bottom.
Oh, that's funny. But yeah, it's a shame that they don't have that anymore. But yeah, we would get the bottles and you could take them and get money for
You
it.
get 2 cents for most soda bottles and 3 if they were like 16 ounces or bigger. Like I forget what they were then, Mountain Dew or lemon lime.
Oh, and then we used to always see you would get more money if it was in New York. We're like, why can't we be in New York?
But man, if you had a penny or two in your pocket after that, and you could buy some candy, you would have.
Oh,
I
yeah.
mean, that's all you had.
Oh, yeah. Those were the days.
Yeah. But
The younger people will never know.
wouldn't even understand this.
No.
They wouldn't understand it.
Oh, we
were
love
looking
that.
for soda bottles and trash in the
Mhm.
street just to buy a piece of penny candy.
Yeah. It's exciting because you felt like you were getting something for free,
Yeah. Yeah.
Thank you.
Hello.
Hey, good morning, Your Honor.
Good morning.
Didn't want to. Okay.
Hmm.
Okay.
Yes.
I usually don't cut it.
Yeah.
Okay.
Got them.
I just wanted to inform the court, is going to get shot. I'm approaching the court reporter.
Oh, sure. All right, Joe Ramos. Good morning. All right, so just one moment. State family violence, is there a special division that handles the online solicitation?
I do believe that would be special crimes, Your Honor, but I could look up the case here and let you know.
All right, it's Joe Ramos. I'm gonna take care of this, but I want the right prosecutor down. All right, so just have a seat and we'll take it up. Yes.
Just wanted to try to get ahead of things. We have the R.C. Curtis matter set in December.
Yes.
And I wanted to, Brennan is the court reporter when we went with the trial. I know there were exhibits already admitted.
All right, if you'll talk with Ms. Ferguson.
Yeah, I'm right. When was it, like Thursday? Uh-huh. Yes, please. That'd be wonderful. I know, look at you. You are like, yay.
No, I don't.
I got a present on your birthday. They did dismiss Douglas Stevens.
Oh, wow.
Thank you for your efforts.
Sure. No, that case, I don't know why it kept hanging around. I'm like,
And Duke.
oh, yeah. Yeah.
I know, that's why I say thank you.
Oh, you're welcome.
And
You know,
happy
the law is
birthday.
the law.
I know.
Yeah. That was a very, very interesting case.
So, right? Yep, it was. So this is what I'm assuming that this will.
Okay.
Yes.
It's just a motion to withdraw. She just wanted me to bring that to your attention. She didn't know if she needed to get.
Well, if they're gonna stand in for the prosecutor, then we can go forward on it.
Okay.
All right.
So everybody's.
All right, Catherine Aguilar.
She's still downstairs, Your Honor.
All right, thank you. Okay, why do I have this on Elisa Hernandez?
She's out here, Your Honor.
Ah, thank you. All right, let me know whenever you're ready. Oh, all right, Elisa Hernandez. Hello.
Hello. Thanks.
How are you doing today? All right, let me just pull up your case. All right. So, Ms. Abrams, this is Elisa Hernandez. Where are we on the evaluations?
Judge, as reported to the court last week, she is on she has an appointment on 11/26 to complete the Tacoma part of the mental health evaluation. So that's where we are, Judge. And that's with the Center for Healthcare Services.
Okay.
That's on 11/26.
All right, so I wanted you brought over, and I'd like to do these updates because I don't want people to be lost. Sometimes the ball gets dropped, right? So they're telling me that the final evaluation you have will be on November 26th. And I'm just trying to make sure you get to the right place you're supposed to be so that you'll be able to successfully complete this. Okay, so what I'm gonna do, counsel, I'll recall it for after that date so that we can make sure that that was completed and we can find out what they deem is the best placement for her.
Right.
So, Vashawn, when do you want to bring it back?
Due to that week being a holiday, I would ask that we either bring it back on the 5th or the 9th.
All right, counsel, the 5th or the 9th?
5.
All right, so we're going to bring you back on December 5th to make sure all the testing is done. They should have the results in and we'll have a placement for you, okay?
Okay.
All right, do you have any other questions? All right, thank you so much for your patience.
Just keep working hard, okay? Just keep doing your job. All right. Let me take these. Okay. All right, have a
Thank
nice
you.
birthday.
All right, thank you. Have a good one.
Have a good day, Jay.
Thank you, you too.
Number 5. Don't think it was domestic violence. Because this relationship. Number 5 is alive, short circuit.
That's a good story.
All right, Joe Ramos. And who's the prosecutor who will take this motion to withdraw it?
Your Honor, I did email the unit to see if they would like me to stand in for them. I just haven't received a response back.
All right, then just give us 2 more minutes. Thank you. Raymond Alejandro.
It is 6 probation, so we're agreeing to probation.
Hello.
Hey, good morning, Judge.
Good morning. Yes.
Oh, we're just coming to announce for trial
All right, we'll have a jury up here at 11.
at 11. Okay, thank you, Judge.
Thank you.
Yes.
Oh, and Matthew, on this case, there's only 1 count, correct?
Yes,
Actually, that is.
And is your client eligible or no?
According to the indictment, yes, if it's,
Okay,
if it's going to be proven as far as the facts that I see, probably not.
okay. All right, I just wanted to know because sometimes I don't know all of the facts of the case.
Yes.
So,
So, but according to the indictment, yes, he could be.
okay. All right then. Thank you.
Yeah, I'll put back in. I know I just. Try that. Thank you so much. Also, yeah, you could, because my hands are Joe Ramos, okay, thank you.
Okay, thank you. Hi, how's it going?
Good. I think you have all the flowers for your birthday, for your birth month.
Yeah.
I have a client on Zoom apparently that is I'm here for Carol, one Uribe.
Let me give you the Zoom link because he's not on.
Oh, he's not, okay.
Yeah.
Because I think he has been approved for pre-trial diversion, but I think you wanted him to appear, so he's on Zoom, okay.
And if you'll have them pull his file too.
Okay, and then where do I get the Zoom link?
Oh, I'm gonna give it to you.
Oh,
right
okay,
now.
okay. Oh, thank you so much. Okay, so you want me to log on too with him and,
Oh, you can just stand here and
Okay.
just have him zoom in and I'll give him his reset.
let me make sure that he knows there's no password or anything?
No.
to get on here? Okay. We'll go do that real quick.
Hi. Hi, you're here.
Yes.
All right, John Ramos.
It's Joe.
Oh, Joe, I'm so sorry. The paperclip was hiding it and I just made assumptions, which I tell people, never make assumptions. All right, court is calling CM 113971, State of Texas versus Joe Maria Ramos. Can I have parties announced for the record for the state?
Kristen Mulliner.
Defense.
Shannon Kitepel.
And are you Mr. Ramos?
Yes.
All right, Mr. Ramos, your your attorney has filed a motion to withdraw. Are you aware of that?
Yes.
All right, do you have any objections to your attorney withdrawing from this case?
No.
All right, state, do you have any objections to the motion to withdraw?
No.
All right, the motion to withdraw will be granted. You're excused.
Thank you, Your Honor.
Thank you. All right, we can go off the record. Mr. Ramos, do you need an attorney appointed to represent you, or are you going to hire one?
I'm gonna hire.
All right, how much time do you need to hire an attorney?
I'm not sure.
All right, this is what we're going to do. We're going to recall this for Norma. If you can recall this for December 9th. All right. So that gives you more than a month to hire an attorney. You'll need to come in on that date with an attorney. Do you understand?
Yes.
All right, Ms. Ferguson will give you a reset form and then you're excused. All right, thank you. Yes, thank you for coming down. Good to see you. All right, thank you. Just give me one moment. Stand right there. Just give me a second, okay?
Thank you so much.
Hello, how are you doing this morning?
I'm doing okay. How are you?
I'm doing okay. Your attorney has medical issues, so we're gonna have to reset your case. And we're gonna reset your case for 2 weeks. Norma, if you'll recall this case, we're gonna recall it for November 21st. If your attorney is able to come in before that, we'll bring you back, okay?
Okay, amazing. Thank you so much.
All right, do you have any questions?
No, ma'am, I actually spoke to him yesterday, so I was just anticipating this.
Okay, all right, thank you.
Thank you.
Catherine Aguilar.
Thank you.
All right, could I see Amanda Moula? Hello.
Hello.
So anyway, the state has filed a motion to dismiss your case. They're saying they're dismissing it because of missing witness. So I don't know anything about the facts of your case, but whatever brought you here, if there's some anger issues, is there something else going on in this case? You need to correct that. Otherwise, you'll be back here. You understand? All right. Good luck to you.
Thank you.
You're
Thank you, Your
welcome.
Honor. Be excused.
Yes.
Take care, Judge.
All right. Thank you.
It goes in waves, right? You know, I want it all the time, and you're not in that. You too?
And Norma, was Gomez on the docket this morning? Joe?
It was supposed to be in our meeting.
Oh, no problem.
I just added him for today.
Okay.
I reset it for the night.
All righty.
Yeah.
Thank you.
Mario Vargas. Hi.
Madison off of docket matter. We were set on last Thursday for probation hearing. I think to address restitution, I was sick in bed and I called Norma
Yes.
and she said she'd let me know. It got reset for this Thursday where I have a CLE, all day CLE. So I didn't know if you would be able to entertain it on this Wednesday or any day next week.
All right. Should I do that for an Aggie? I don't know. You know, you disappoint me. First you break our hearts
And then
you don't. Yeah, I'm like,
and they were tough.
yeah. All right, so which date are you asking for?
Any day next week, I guess oh, we do have court Monday, right? Or Veterans Day? We off Veterans Day?
Yeah.
Okay,
Uh, we can do it the 12th
12.
or the 14th.
How about the 14th? Yes.
All right,
Okay,
yes,
thank you very, very much.
you're welcome. Let me put it in the system. And you'll notify your
I
client?
will. I know right now. You want me to take the file to the clerks or she'll?
Oh, just 1 second. I have to put it in the system. So what CLE do you all have?
It's a 2-day DWI CLE at the Minger, Stewart.
Oh, okay, stop by.
Yeah.
If we're not in trial, which, you know, we're probably gonna be in trial.
Four courts trials, something like that. LSU Bama, is that this weekend? Is that this Saturday? In Tuscaloosa?
We'll see what happens. We still have a chance to be in the playoffs, so we shall see. And Norma, anybody who's remaining, they're gonna come back on Thursday.
They can share it on the back. No. Yeah. Really came in. Yes. And I don't know.
Hello.
Hello, I'll process it this way.
Okay, sure.
Unless, we were here last Thursday,
Mhm.
you, Miss Monique Williams, and myself.
Yes.
They withdrew the MTR. We discussed we're going to the CPS office for supervised visits.
Yes.
You said to bring you a order. I got you the whole motion with the address and.
Okay.
Monique's not with me, but
Okay, no, that's fine. State family violence,
actually it's not a family violence case.
it's not?
There.
Well, I mean, but, all right.
Yeah,
Jason,
they were present last time and.
Yes, I
they had-
know.
They had no. We were here last Thursday. You guys withdrew her into Monique. Well, discussing the matter with the judge further. She's got supervised visits with her children at CPS. The judge wanted me to bring an order, information, which is a veteran still. It's the address, date, time, every Wednesday, hour and a half.
I mean, so she's remaining on GPS.
Yeah, yeah.
Asking
she's
for permission to go to
permitted
CPS.
To go into the CPS, there's an
Okay.
address, yeah, yeah.
Just-
CPS for supervised visits.
If that's the case, to go to the actual CPS, I mean, we're not opposed to that.
okay, all right, thank you.
Thanks, Ashley. But the police. Because the female victim is allegedly made threats that I will kill your baby. The baby died the same day as assault. And you're complaining as bro.
Let me just put this in the system.
Sure. No, it should have been e-filed this morning, but
Okay, oh, you know, it gets lost.
I know. I had my secretary do it this morning. And we're still on for the 18th.
Yes.
In about less than 2 weeks.
Oh,
Today the
yeah.
4th, 2 weeks.
Mm-hmm.
Maybe we'll be celebrating tomorrow.
All right. So if you'll make sure the clerks get it.
Okay.
Thank you.
We're signed.
Yes.
And my secretary e-filed it, but she just put them in the computer too. Okay. Just a random page. Hmm? Oh, okay, okay. Thank you, Judge.
You're welcome.
Monica,
Isidore Heredia.
Monica Guerrero represented a guy who was in a wheelchair
Oh, yeah, I heard.
the whole time at the jail, all through trial. They make accommodations for a wheelchair. Jury gives him the rest of his life in prison. He goes into Sally Port and faults runner.
Except for, I'm telling you, it was straight out of a soap opera, right?
I mean, it was a scheme he planned all along.
Yeah.
And
It took commitment.
yeah, yeah. And they caught him over at the sushi ushi.
Ah, sushi.
Is he, yeah, somewhere like that.
Oh,
The sushi place.
Yeah.
Monica goes, well, somebody, man, that's not my guy. My guy's in a wheelchair.
Kelly, I think your guy is present on Zoom.
Yes, okay.
Who is he?
Juan Uribe.
Can I see the file on Juan Uribe, please? And Norma, I need a date for PTD. All right, Mr. Uribe, you need to
Yes,
show
ma'am.
your video.
Okay.
Hello.
Hi.
Hey. All right, we're gonna bring you back on December 5th. You can appear by Zoom, all right?
December 5th?
Yes.
Okay.
All right, and you can appear by Zoom.
Okay. Thank you, ma'am.
All right, you're welcome. Have a great rest of your day.
You too.
Thank you, Judge. You're welcome. Yes. Thank you. Okay. All right, are the parties ready on Arabia?
Yes, Judge.
Who's the prosecutor on Isidore Heredia? All right. All right, everyone, we're gonna go. Kurt. Court is calling 2024 CR 6568, State of Texas versus Isidore Aridia. Can I have parties announced for the record for the state?
Your hand, Your Honor.
Defense.
Suzanne Kramer for Mr. Heredia.
And are you Mr. Aridia?
Yes, Your Honor.
All right, we're here for sentencing. Have both parties had a chance to review the PSI report, state?
Yes, Your Honor.
Defense?
Yes, Judge.
And the TAP evaluation, state?
Yes, Your Honor.
Defense?
Yes.
Any objections to either state?
No, Your Honor.
Defense?
No.
All right, you applied for deferred adjudication. You entered a plea of no contest on September 17th. According to your plea bargaining agreement, punishment is to be assessed at a cap of 15 years in the prison. There's an affirmative finding of deadly weapon, and the state is opposed to your application. Are there any witnesses from either side? State?
No, state.
Defense?
No, Judge.
All right, so it's just argument?
Yes, Judge.
All right, state you're opposed. I'll hear your argument.
Yes, Your Honor, because of the previous record and also the issues. State's house.
All right, defense.
Yes, Judge. He has been to prison once before. It was back in 2017 for an ag assault deadly weapon, as you can see from the report. One of the good things I saw when I was going through this PSI, which you don't normally see, is that he is very motivated for treatment, full-on safety. If you read the facts of this case, because of his drug and alcohol, primarily drugs, but some alcohol use on this particular day, he really does not remember the offense. His birthday was the next day. That's also the anniversary date of his grandmother's death, who he was very close to. He does live and would live with his grandfather, should you see fit to give him deferred. I know that it's an ask because he's been to prison once before. His misdemeanor history is, he's got, I think, a DWI conviction, I think maybe an assault married conviction from a while ago. But if he goes to safety, that's like a good 9-month hit of intensive treatment that I think would serve him much better than going to prison, where he's not, even if he did therapeutic community, it's not going to do him as well. And clearly he needs, he's never really gotten any help from the system. He just went to prison on that ag assault. Looks like he did get deferred initially, but he wasn't really getting any kind of help. And I have talked to him. He has always accepted responsibility for this offense. He never did want a trial. He knew that he did wrong, which I think is shows that we might be able to actually get him the help that he needs so that he can get his life together. He goes to prison again. I'm not so sure he's going to get out, and with any of the help he needs, it's going to be just, I think, setting himself up to fail. Is there anything you would like to let the judge know?
You want to raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, Your Honor.
All right, you can lower your hand, state your name for the record.
Go ahead, Ebia.
All right, what would you like to say?
I mean, I know I messed up, Your Honor. I understand that, but I mean, I really been to prison. I feel like if I go back, that's really just not gonna do anything but to help me. It's just really gonna send me in a spiral. I mean, when I was on probation, I never got any help that I needed. I always wanted help. I struggled with doing drugs. When I lost my grandmother on my birthday, that kind of hurt. And then soon after, I lost my little brother who I initially grew up with. So it kind of sent me in a spiral. And then in prison time, I lost my son to CPS because the mother of my child was on drugs and didn't really want to try to get my son back. So that really hurt him. And the only support that I have is my mother, my father, and a good friend. He's still by my side no matter what. He's just encouraging me every day to do good and wants to see me do good. But I never had any type of help. I would really appreciate if I can get any type of help.
So you're telling me when you were on deferred adjudication, they didn't give you any help? Because according to what I'm reading from the criminal history, you were on deferred adjudication for aggravated assault with a deadly weapon. There was a motion to revoke file. Now, I'm making assumptions. Usually when there's a motion to revoke that's filed, that means that they're alleging that you violated some conditions. And whatever condition you violate, they are supposed to address that if they're continuing you, address that. For example, if there's a drug issue, then they'll address it by giving you drug rehab. If there is an anger issue, they'll address it by giving you a class on anger management. So you're telling me none of that was done?
No, I was on class doing a BIP band intervention program class, and for them altering my days of class, which kind of gave me a revoke.
So you're saying they gave you BIP?
Yeah.
So this aggravated assault with a deadly weapon, that was against a relative or a family member? All right, and then you had the possession less than 28 grams. You were given deferred adjudication for that. And you were revoked. So you're telling me in all the time that you were on probation in those two instances, nobody offered you any help?
On the band, and when I was on probation for the 6 years, they were supposed to send me to ISF, but due to COVID, they never sent me to none of those.
Okay.
And just as an aside, Judge, he's only, I think.
Oh, well, I'm sorry, just 1 second. Do you have any questions for him?
Yeah.
State, do you have any questions? All right. So,
He's 28 now. So when all of these other offenses were happening, looks like it to be about 8 to 10 years ago, he was very young. And it really didn't have any, probably the emotional or the brain development to really have taken advantage of whatever he might have been able to take advantage of. But he's older now, much more mature, looking at 30. And I think he would take this seriously. Of course, if you so chose to give him deferred and he goes to safety and he doesn't comply with their rules, back he comes, and you can obviously send him to prison then. But I would like to see if maybe we could give him that chance.
all right, so here's my question. My understanding, your attorney is saying that you were going through some things. So according to the facts of this case, you're offering to buy an item for someone. Is that correct?
I don't recall, but if it says yes.
No, I mean, it's saying that somebody set up to buy an item. I don't know if this was on OfferUp or whatever it was on, but the person arrives to sell his item and then a weapon is pulled on them. It was agreed that the purchase price would be $500. And then you pretended to reach in your pocket for money to pay. And then instead you pulled out a knife and pressed it to the victim's ribs and told the victim you were going to steal the phone. And then you had the wherewithal to change, I guess, I'm from the 70s where you had CBs and stuff. So you changed your handle from what it previously was to the P word. So, I mean, you had the wherewithal, even though, you're saying you had drug-induced issues, you still had the wherewithal to go in and change your account name and everything. And you had the wherewithal to reach out to someone to make a plan to buy an item from them and then set up a place to meet. But you're saying all of this was in a drug-induced haze?
Yes, sir.
Do you see how that sounds?
I see how it sounds. Well, at the time I was doing Xanax, and Xanax, when I do them, it was causing blackouts in and out. So I really don't remember.
And then see, the thing for you not to remember, because you're telling me you're not remembering, obviously something happened that made you remember because you went in to change your name, your handle, from where this person, from where you had previously reached out to this person.
And Judge, of course, I'm not a psychologist, obviously by any stretch, but I mean, over all of the years, I think while if he's in a drug induced and he can't remember anything later, I don't think that necessarily means that at the time he wasn't able to function and, obviously do what he did. He just doesn't recall it later once the drugs and the alcohol were off.
Okay. All right. Thanks for explaining that. I appreciate that. All right. I just don't think you're appropriate candidate for deferred adjudication. So I'm not going to grant your application. I'm going to find you guilty. There's an affirmative finding of deadly weapon. I'll ask for the therapeutic community because of your history. They may not place you in that. I have no authority to force them to place you there, but I do know if you don't ask for it, they definitely will not do it. I'll put in the judgment therapeutic community.
Thank you, Judge.
There's to be no contact with Daniel Anthony Guevara, Guevara. And just one moment. All right, now let's speak to time. According to the plea bargain agreement, it's cap of 15. States you're asking for 15. All right, defense.
Well, of course, Judge, I'm going to be asking for less than that. I think he went 6 years on the last stint, possibly. So I was telling him that I would ask you if you would possibly be willing to consider 8. Should you not be willing to grant the deferred?
All right. All right, the court is going to sentence you to 15 years in the prison. I'll give you credit for any time served. Did you review the trial court certification of defendant's rights to appeal with your attorney? Did you understand it?
Yes, sir.
All right, because this is a plea bargain agreement, because it's your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, sir.
All right, we can go off the record. This is what I want you to understand. I take no joy in sending anyone to prison. I am still hopeful that you will do well. I know that 15 years is a lot of time. Any day that you spend in custody, even if it's an hour, it's a lot of time. I understand that. But you're going to have to change your ways, because otherwise what's going to end up happening is you're going to find yourself spending the rest of your life at the prison. And when you look at your history, if you pick up a new case, people are going to see that history, and your minimum is 25 years. And the law is the law. However, if you end up going to prison for 30 years, when it comes time for you to go to parole, they're going to look at your criminal history, and they may be inclined to let you sit there for the full 30 years. You understand?
Yes, sir.
All right, so there's still a chance for you to improve yourself, to get your life together. So while you're at the prison, there are plenty of programs that are there for you. Read, get an education. They will give you an education for free. If you don't have your GED, get your GED. Work on improving yourself and do not become institutionalized. Do you understand?
Yes, sir.
All right, good luck to you, okay?
Thank you, Judge. Maybe be excused.
Yes. Deputy Laura, what page is Herrera on?
You're on page 6 at the bottom.
All right, thank you. Kevin Wright.
Morning, Your Honor.
Good morning. Right, so my understanding, you all are requesting jury trial, correct?
That is correct.
All right, how long do y'all expect this trial to last?
3 days.
All right, I need a jury trial setting, criminal trial division, 2 to 3 days. Yes. All right, so you're gonna come back on December 2nd for jury trial. You'll be brought over dressed in whatever civilian clothing you have at the jail. If you wish to be attired in something other than what you have, you'll need to speak with your attorney and do a clothing exchange. Do you understand? All right, and state on this case, do you have a acknowledgement of discovery? Has that been completed?
Judge, I have a special setting on the 175th on that date.
All right, we'll see what happens.
It's a murder case, so. Okay, it's all right. No discovery, yeah.
All right, so if you all can get an acknowledgement of discovery done, please.
Yes, sir. Yes, ma'am.
All right, thank you. Edgar Aguilar. All right, could I have the interpreter call? Darren Johnson. Good morning.
Morning, Judge.
Good morning. How are you doing?
Fine, thank you.
All right, we're gonna get you a jury trial date. How long do you expect this trial to last?
Probably 4 days, Your Honor.
4 days? All right, we shall see. All right, Norma, Darren Johnson recalled for December 2nd for jury trial. All right, once you sign the reset form, you're excused.
Judge Boyd,
All right.
have a pleasant birthday.
Oh, thank you so much, and thank you. You always dress appropriately for court. I
Thank you,
appreciate
Judge.
that. Thank
Be
you.
excused.
Once you sign the reset form, just have a seat and your attorney will bring the form to you.
Thank you, Judge.
All right, thank you.
Thank you, Your Honor.
You're welcome.